Hello friends, welcome back to NRI Samay. Wherever you are in the world, a very warm good morning, good afternoon, good evening. Recently I was talking to Dr. Jayaprakash Narayan on NRI Samay, and he mentioned that India has a very low conviction rate of around 6%, while in Europe it's around 30 to 40%, and US is around more than 90%. And an interesting case unfolded recently, the case of Revanth Reddy, the MLA from Telangana, who bribed another people's representative for an election in the state of Telangana. After looking at the conviction of and acquittal of Jayalalitha, conviction and bail for Lalu Yadav, a conviction and bail for Sukram, might sound a little cynical, but in a broader perspective, for judiciary, this case of Revanth Reddy, who was bribing another people's representative, might be a petty political case, and for media it's a TRP item, and for political parties it's a matter of blame game. Decades will pass by and politicians will keep saying, don't blame me because I'm not convicted yet. In a nutshell, the Revanth Reddy case has enough strength to stick around and trouble him forever, and far beyond. The visuals are so powerful. If anyone can take a look at it, it's there on YouTube and other places. Brushing aside politics, which is what everyone talks about, what next for Revanth Reddy in terms of legality is the most interesting thing that we got to look into. And joining me now from Delhi is a law student at University of Delhi at Faculty of Law, Pavan Bhushan, to explain more about the depth of this case. Sir Pavan, thank you so much for joining this quick call, sir. Welcome to the program.
Thank you, Shrikant Bhau, and I'm glad to be speaking on this.
Thank you.
And thank you for your generous introduction and also a broad overview on this recent case of Mr. Revanth Reddy.
Yep. Thank you so much, Pavan Bhau. So most of the times I keep bugging you with all this Supreme Court judgments and all. And thank you so much for enlightening. Whenever you get time, I keep bugging you on this. Thank you.
No, not at all.
Yeah.
I find this fairly interesting, and I study it or work on it every day. So it's my pleasure.
Wonderful. Sir, one thing, see, Telangana Anti-Corruption Bureau arresting Telugu Desam Party MLA Revanth Reddy on the charge of trying to bribe a nominated member of Assembly representing the Anglo-Indian community, Elvis Stephenson, is a classic example where a bribe giver is involved and the person to whom bribe was offered has informed the authorities, ACB here, which I'm referring to. Sir, this seems to be a very strong case, right? Is this, once again, just a media item, or does this case have enough muscle? What do you think, Pavan?
So, apparently the information through news items, etc., suggests that this was also caught on video. He was caught giving it red-handed, and the anti-corruption branch was informed almost immediately thereafter. I think it's a very strong case. It certainly depends on the Indian judicial system, which everyone knows to be very slow, and by seeing the manner in which the ACB has gone about it and the vigilance with which they have been working, it is definitely a strong case. And the only hurdles will come in trial depending upon the judges, because if there is a strong proactive judge, certainly this is a very strong case, and the anti-corruption branch already has a lot of material to prosecute the MLA in question.
So true. And we keep hearing about these fast-track courts, right? Pavan, a lot of times when there are high-profile cases, many people say, why not start this fast-track courts and finish these cases? And also, recently we've been talking that, somebody who's convicted and they lose their representation in the assembly or in the parliament. Fast-track courts, how realistic is this fast-track courts, and how's that functioning as in a broader perspective in a country when people talk about fast-track courts? What's your opinion on fast-track courts, Pavan?
See, eventually even a fast-track court is a court of the Indian judicial system. Sometimes if courts are proactive, a separate court, a special court itself is set up to try one whole case, as was the case in Mr. Ramalinga Raju's case, as was the case in Mr. Lalu Prasad's case. Same was the case in Madam Jayalalitha's case. So, in all in many of these high-profile cases, courts set up a special court which is only for the purpose of that case, and because they're only hearing one case, they're usually likely to be faster, and they tend to proceed on a daily basis. So they are in practice also faster, but they're manned by the same people. The same lawyers argue those cases. So if the other people are same, often we see that even a fast-track court does not result in a faster hearing, in a faster wrapping up of that case. But yes, it is definitely a step in the right direction, and because of fast-track courts, we do see certain convictions or acquittals, as the case may be, depending upon the evidence on that case, in a quick manner before a special judge.
Right, and certainly a fast-track court is a matter of government taking it up, right? This case, especially when we talk about this case, it is possible that the government can be proactive and then take a fast-track court route and then get this wrapped up fast, right? It's a matter of commitment and conviction, right?
Yes, certainly. It is completely a matter of commitment and conviction, because finally in any state, the prosecuting agency, even though the prosecutor's role is to be slightly independent from the government and try and be unbiased and also give the benefit of doubt to the accused, but the prosecutor often gets influenced by the prosecuting agency, which is that state.
Mm-hmm.
That state in which that FIR or crime has been registered.
Right.
So,
fair enough.
That prosecuting agency, depending upon their political alignment, their interests, their closeness to the person in question, the accused.
Exactly.
So these factors do come into account when they decide how actively to take up a case, whether to completely put it in cold storage or not.
Right, and certainly a political space, so anything is possible ever.
Yes, absolutely.
Yeah, and Pavan, this gentleman was elected by people, and being the representative in democracy, what's the role of citizens here who elected with good faith, right? They elected him with good faith. And can't these citizens do something in regards to this issue? Did such episodes ever happen?
So, unfortunately, in India, yet there is no right to recall. A right to recall would be that citizens in a constituency who have elected their representative, after a point, if they see their representative acting contrary to their wishes, would have a right, by moving a motion by a certain minimum number of signatories of that constituency, to vote on a motion of recall, to recall that candidate and end his period of office by declaring that he is not fit to be elected from that constituency.
Oh, so a right to recall would have made sense.
Yes, in such cases a right to recall would make sense. But there is no right to recall in India currently. And mostly citizens in such cases don't have any recourse but to vigilantly keep informing the investigating agencies of what is happening, informing the other reasonable legislators about defection, etc. And otherwise the recourse is just the next election. And which is why we see that when legislators facing re-elections come close to their elections, they suddenly seem to develop a keen affection towards their constituency.
Right. Right, so true.
Citizens who have elected in good faith, the least they should do is when that person comes for re-election is try and be informed of his past deeds. The problem here is that since a large section of the electorate is not aware, does not have access to information, it is not their fault that they are not aware. Often a lot of people in India have to struggle for their daily survival. So it is a luxury to even be informed of such issues.
Right.
And if people can be more informed, then certainly it would lead to people being more vigilant, people not allowing such candidates from being re-elected.
Right. Fair enough. And Pavan, I've seen this question come up on Facebook and social forums. How can ACB arrest an MLA? Is ACB meant for government employees, taking action on government employees? How can it arrest an elected representative? Under which section can it arrest people's representative? Any information on this?
Actually, this is an interesting question, and this has been discussed for at least the last 40 years, depending upon the law at that time in that place. So, in the past, misconduct by a government official would mostly be referred to as a public servant,
right,
in technical terms, because a public servant is defined in the Indian Penal Code. And the Prevention of Corruption Act only came into existence in 1988. Prior to that, it was only the Penal Code, and most of the prevention of corruption offences were also listed in the Indian Penal Code.
Okay.
In this famous case, R.S. Nayak versus A.R. Anthule, this question came up before a bench, constitution bench, whether public servant in the Indian Penal Code of that time. So this case was decided in 1984, prior to the Prevention of Corruption Act coming into place.
And it is between Nayak and Anthule, is it? What's the background of that case, Pavan?
It was a corruption case where a bribe was also... for the purpose of this conversation, I feel we should... my primary motive for using that case is to show what the term public servant includes.
Got it.
Because one of the major questions that arose in that case, because Mr. A.R. Anthule was a legislator.
Right.
Can a legislator or member of parliament, MP or MLA, be considered a public servant under the Act?
Okay.
So, basically, there are three interesting clauses in Section 21 of the Penal Code. And one of them, which invited a lot of discussion on part of the court, was a public servant is also one who is remunerated by the government. So, the lawyers trying to arguing for the proposition that an MLA is a public servant tried to state that if an MLA is drawing his remuneration, which he is, from the government, then that person should definitely be considered a public servant for the purpose of prosecuting him under the Penal Code. But there was a long discussion, and it was concluded by the judges that this remuneration by government servants was only meant in the sense of a master-servant relationship, which means that the government must be exercising some sort of administrative control upon the person whom they are paying, whom they are remunerating. It wasn't meant for some completely different person who was also being remunerated. So there was this distinction made, and it was held by the court that in the Penal Code, the word public servant would not include a MLA or MP, because the legislator is not one who is remunerated by the government in the sense that it is working for the government. And in Anthule it was established, and for the next 4 years this principle was practiced, that an MLA is not a public servant. However, in 1988, this Prevention of Corruption Act came into force. So again, the Prevention of Corruption Act defines public servant again. And there were certain other aspects included which were not included in the penal code. These aspects included this one clause, which is section 2C8, which reads as follows. Any person who holds an office by virtue of which he is authorized or required to perform any public duty is also a public servant. So, now this is also not a very clear clause. Many people, after the coming of the Prevention of Corruption Act, argued that even this 2C8, any person who is authorized or required to perform any public duty also may not include an MLA or an MP. So, this question came to be decided in another big case, which is P.V. Narasimharao's case. It was decided in 1998. And in this case also, the offerer and acceptor of a bribe, both were in question. Here, the court held that any person who is authorized or required to perform any public duty would certainly include an MLA, because MLAs and MPs are essentially performing public duties. They are elected representatives of the people. Any duty that they perform has to be with respect to what the people have asked, what the people have voted that MLA in power for, and essentially any duty being performed is for the public. So it is a public duty in that sense. And by interpreting this in Narasimharao's case, the court authoritatively laid down the law that under 2C8 of the Prevention of Corruption Act, public servant certainly includes a MP or an MLA. So that's basically how this evolved. And today also, a legislator or an MP is a public servant. So that person, every law that applies to a public servant will apply to an MP or MLA as well.
Wow. So, how can an ACB arrest an MLA? Yes, ACB can arrest an MLA because he's a public servant. Is ACB...
Actually, yeah, there are two aspects to your question. One is how can the ACB arrest a public servant, and whether an MLA is a public servant.
Yeah.
Finally, that's how we can break it into two parts.
Right.
And the former, since I haven't responded to that, the former is every state has a police, and the state police has powers to arrest under the Prevention of Corruption Act. The Anti-Corruption Branch is just a name given to a police station which deals with corruption matters only, because sometimes they're more technical in nature, so you need more competent officers to investigate such offences, and that's why you form a separate anti-corruption branch which may investigate only corruption cases. But effectively it's a police station. It is the police of that state investigating, and any crime against any public servant can be registered in that police station. Any FIR can be registered and can be investigated. One of the sources of confusion currently could be that in Delhi, the ACB is not a state, is not under the state, because Delhi is not a state.
Right.
So your question seems to be coming from the background of what has been happening in Delhi. And Delhi is a peculiar territory. It is a union territory with a legislature, with a legislative assembly, which does not in any way have the powers of a state. It has powers insofar as the union allows. So even actually the power to set up a police has expressly been kept with the union for the purpose of governing Delhi. But
okay.
Delhi is a different subject, so we'll keep it aside. But
right. But at least in the state of Telangana,
can certainly move upon any public servant.
Got it. So at least in the state of Telangana, which is not in union territory of anything of that nature,
yes.
An ACB can arrest an MLA, and essentially I've seen the IPC Section Acts and also the Prevention of Corruption Act for especially this case where Revanth Reddy was involved. All right. So under which section can it arrest people's representative? Which sections? I think Prevention of Corruption Act and IPC you have mentioned. So would that be relevant here, right?
So actually there are several sections in which they may be arrested. They're being arrested as a bribe taker or a bribe giver, because the Indian law does not discriminate between the two, because even abetment to the taking or receiving of a bribe, abetment includes the giving of a bribe, is an offence. But actually I'll just take a moment to sort of differentiate between the two, because the two
Sure.
would most likely fall in different sections of the Prevention of Corruption Act.
Right.
But the IPC we'll keep aside, because mostly with respect to prevention of corruption, the IPC is used for including the offence of criminal conspiracy.
Right.
Criminal conspiracy being 2-3 people together committing an offence.
Okay.
And one of the problems actually in Indian law is that it does not differentiate in intent behind the bribe giver or the bribe taker. So, but what I mean by that is, there are certain things that one who has gone to any government office or any authority is entitled to. A private citizen is entitled to, for example, if I qualify, I am entitled to a ration card. If I qualify, I am entitled to a driving learner's license. While the exact driving test I can pass, and that is the discretion of the transport authority to confer a license, but at least a learner's license, depending upon me passing the test. If I have objectively passed the test, I am entitled to one.
Right.
Once I am entitled to one, it cannot be said that the person taking a bribe is for giving me something I am not entitled to. If I have to pay to take something that I am not entitled to, then it is me trying to influence a public authority or a public servant to get what I otherwise do not have a right upon. And
right.
It is the discretionary power of the government official or the public servant deciding whether to confer that upon me or not.
Right.
Whereas, if I am paying to get something that I am entitled to, which is something that I have a right upon, then there can be a safe presumption against me trying to unduly influence a public servant. Because where I have a right, the presumption is that the person who was responsible of administering it to me was not asking for it, was asking for a bribe.
Right.
So this distinction is not made in Indian law. But coming back to the provisions, if we see the Prevention of Corruption Act, Section 12. Section 12 is, it primarily relates to when a person has abetted certain offences. Actually, it talks about sections 7 and 11. For our purpose, I think 11 is more important.
Okay.
To give a brief background of these. So, 7 is a public servant taking gratification other than legal remuneration in respect of an official act.
Okay.
Now, So, for an official act, I am taking remuneration. Now, so I won't read the whole section because
just a summary should be good enough.
Reading it is much more useful than listening to it.
Right.
So I'll go to the relevant part of first 12. Punishment for abatement of offences defined in section 7 or 11.
Right.
So it says whoever abates any offence punishable under section 7 or 11, whether or not that offence is committed in consequence of the abatement. So the abatement may be just in furtherance of the offence. It does not depend upon that offence being committed in consequence of that abatement.
Right.
That person shall be punished and that punishment is prescribed. That also, punishment can be set aside for the purpose of understanding it.
Okay.
Once you abet a public servant from abet a public servant to obtain a valuable thing without consideration from a person concerned in some proceeding or business transaction, or you abet any sort of bribe. So if I am going to a public office and I bribe someone, I am abetting that official taking a bribe in his official act.
Right.
And because I am instigating him, abatement is defined under 106 of the Indian Penal Code. And instigating someone to take that bribe, by offering him, I am instigating him to take it.
Exactly. Yeah.
And that is an offence. That is an offence under 12. And so I've seen recently most of the offer to bribe cases are 120B of the Indian are section 12 read with 120, criminal conspiracy, because finally the bribe giver and taker are conspiring.
Right.
However, there is a fine line here.
Yes.
Because an offer of bribe may be rejected by the acceptor.
Which is what we see in the Revanth case, right?
Yes, exactly. So, in that case, only the bribe offerer will be charged under this.
Okay.
Because the taking of gratification, it does not mean, it always includes, it says accepts or obtains or agrees to accept or attempts to obtain from any person.
Okay.
So, it is three things. It is accepting. So, in a case where the receiver has reported, we cannot say that he was accepting it.
Okay.
Nor can we say that someone else influenced him to obtain it.
Right. Exactly. So I think in this specific case, it's a classic case where I think Stephen, the person who's basically offered the bribe, Stephenson, he is not. He doesn't come under any of these clauses that we're talking about, which is good. Pavan, I have. Go ahead.
There is a string of cases where even entrapment by a media official of a public servant, where that person to some extent misleads the other person into saying that he is willing to bribe. So, for example, a media person with cameras goes to a public official and tells him that I am willing to pay for this act.
Okay.
Now, if an entrapment, so entrapment is otherwise an offence, unless it is done in public interest. That exception has again been made by the Supreme Court in the last 10 years, in cases of the last 10 years.
Okay.
Where they've held that entrapment also, only in public interest is it not an offence, because finally the person trying to entrap is also offering.
Right.
So there is a thin line there, and that is slightly vague, but we'll come to that later.
Yes. Yes, certainly.
And
Pavan, there's one other interesting thing, right? The politicians get caught, and when the video evidence is given, they say that the video is fake video and tampered. And the ACP authorities that I'm referring to an article in Hindu that came in just a few hours back. The ACP authority officer says that mere video footage leaked by unidentified persons is not sufficient enough to, or is not a sufficient evidence to examine a person. What is the deal with this video evidences, Pavan? Did video evidence ever make any difference as far as the judicial proceedings are concerned? What's your take on this?
Yes, certainly it does make a difference. Video evidence is extremely important. But, such statements are made when the media airs these videos, because that's the only way the public can be informed of what is happening. But when the media airs these videos, at that time no forensic examination of such a video has happened. Such a video has not been led as evidence in a court of law, even though it is evidence with the police to prosecute. But yes, it is always an argument taken in caution by an accused or an accused lawyer. It is a safe argument to take in court. First, doubting the authenticity of the video, because the authenticity needs to be verified by forensic experts. It is fairly easy to verify the authenticity of a forensic video, and but that has to be done by some expert authority.
Got it.
And so prior to that happening, prior to that being taken on board as forensic evidence, it is certainly extremely important evidence, because it is hard to completely forge video. It is not easy to make a fabricated video, and so it holds weight. The only thing is that the accused is given every chance in his defense, and very fairly so, to try and disregard that piece of evidence for any irregularity.
Right. And I think we got past half hour here, Pavan. So what type of sentence is maximum for this sort of offense? What can we expect from this?
So the Prevention of Corruption Act gives a maximum sentence, and under Section 12, it would be, I'll just check for you.
Sure.
Under Section 12, it will be, which may extend to 5 years and shall also be liable to fine. So it is not less than 6 months, up to 5 years, and fine, which means that it could be anything between 6 months and 5 years, and a fine of, depending upon what the court deems fit.
Okay. And at this point in time, because he's right now in jail, he's been arrested, and he's lodged in Chenchalguda jail right now. Does he need to resign as an MLA, or still he can be a people's representative with all this?
Yes, if an MLA is accused of any act, that does not make his seat fall vacant, or that does not make that does not create any obligation for him to resign.
Okay.
His seat falls vacant only on conviction.
But how about government official? Let's imagine a state government, an endowment officer, or some other irrigation.
Yes, that's a separate footing, because thing is, there is a separate departmental inquiry that begins. Pending departmental inquiry, one may be suspended, one may be sent on leave, depending upon different service rules of that area.
Right.
But
a people's representative is different?
No, so an MLA being, he's not holding any office where certain decisions are being made. So immediate suspension, finally that suspension is also from the office. That suspension or leave is from that office.
Right.
That person, even a minister, is not resigning from his elected seat. That minister may resign from the Ministry of, say, Telecom or Science, pending serious allegations. That person may be removed from discharging any functions under any ministry or powerful post. but that person's candidacy does not fall vacant, because that person is still an accused. His fair trial is pending, though the case may be such that there may be no doubt, but still that trial has to happen for him to be convicted, and only after conviction does the seat fall vacant.
And with this weakened judiciary, a conviction is expected to be in 15-16 years from now on. As things are happening right now, at least in a political space, I see that convictions are very, very slow. Not being cynical, but that's how it has been, right?
That's true. I don't blame anyone for being cynical, because it is how that has been. But so many factors come into play, and let's hope that his trial also happens in fast track.
Yep.
That they're able to set up a special court to try this quickly.
Absolutely. All right.
Yeah.
Pavan, thank you so much for your time, sir. It's been a phenomenal half an hour. A lot of information, a lot of insights. Judicial matters are not that easy to describe or even discuss. And, it's always a double-edged sword wherein the words here and there would really fall apart. As and when, for all the conversations that we do on NRI, in terms of judiciary, medical purposes, or whatever it is, we request listeners to take this as a conversation, discussion, and a material for them to understand the deeper perspectives of these issues, but not in a holistic view where they take it in pieces and then knit together with facts. So, thank you once again, Pavan. It's a great time.
Thank you, Shrikantji. And I, subject to various corrections in what I've said, I'll also try and write down something which is more exact. Because
Wonderful.
While speaking, by describing, often people may poke holes in what I've said. That is obviously subject to critique.
Yes, and it's quite normal, and it's a conversation, it's a discussion, and it's just an exchange of thoughts as far as the issue is concerned. We request all the NRI Samay listeners to not take a holistic view of this, but it's just an content or a material that's out for their consumption in terms of understanding the issue in a deeper terms than what is there outside. A lot of people right now would understand the political side of it, blame game, saying that this is a political trap or whatever it is. But the deeper issue is that there are institutions involved in this whole process, whether it is judiciary, whether it is income tax departments, whether it is enforcement directorate, or whoever it is, ACB. There are multiple institutions that are involved in this. It could be an assembly ethics committee as well. So it's just there's too many pieces to this story. We would urge all the listeners to as well, dig deep into this as much as possible and not take this into totality as far as coming to conclusions on this issue. Thank you so much once again, Pavan.
Thank you. Thank you,
sir. Have a great day. Bye.
You too.
So, friends, that was Pavan Bhushan. Pavan is a law student at Delhi University and the University of Delhi at Faculty of Law. Would be an advocate very soon, and Pavan has some deeper insights into the judicial side of aspects. So, at NRI Samay, I would like to thank for his time in explaining things in detail. And as you know, that in India the conviction rate is very low, and the recent episode of Revanth Reddy might not go anywhere, but still it is a case which has powerful visuals, and also the strength to that case lies because the elected representative, the nominated representative, the MLC, has notified essentially the Anti-Corruption Bureau. So I hope you have got good insights listening to this conversation. Do come back to NRI Samay every week, Saturday and Sunday, same time, 9 a.m. Pacific U.S. time, 12 p.m. Eastern time, and 9:30 p.m. India time. You can also listen to all the conversations on NRI Samay at youtube.com/NRI Samay, facebook.com/NRI Samay, twitter.com/NRI Samay. Any comments, any suggestions, any feedback, any questions, you can write to us always at nrisamay@gmail.com. Thank you so much. Have a wonderful weekend. Bye.